Stand, please. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 22-5264. Michael W. Langeman, appellant, versus Merrick B. Garland in his official capacity as Attorney General of the United States et al. Mr. Berger for the appellant, Mr. Sturgill for the appellees.
Mr. Berger, good morning.
Thank you. Thank you very much.
Whenever you're ready.
Okay. This is a case that is exclusively focused on process, not on the merits. Not going to be any discussion of merits of this case. The employer of this civil servant, he's been employed for 19 odd years. The employer claims that it can summarily discharge him, remove him from service without notice, without an opportunity to be heard on any charges, simply because it claims that there were exigent circumstances, compelling circumstances, such as safety to the public, the fellow employees, but yet nowhere in its discharge papers did it identify in any way what those exigent circumstances were.
Okay, go ahead. I just want to start out because you said it's focused on process.
Yes.
So if we're talking about a property interest, are you talking about the property interest in the expectation of continued employment or property interest with respect to an expectation of process?
It's a property interest in the expectation of continued employment, that there is an objective basis provided by his employer that tells this gentleman that he cannot be summarily removed unless there are exigent circumstances. And the employer is obligated to at least identify what that consideration is.
Where does, I actually have the same question, but let me ask it this way, which is, where does the free memo limit the substantive grounds on which an employee can be terminated? I don't think it does.
Yeah, well, at the free memo itself, quote it, these protections, that is a due process, will not apply to extraordinary cases which require immediate summary dismissal. I must preserve discretion. And then it defines what conditions the discretion. I preserve discretion where there's an exigent circumstance.
In order to distinguish between one category of circumstances where the normal processes apply and a different category of circumstances where summary processes are allowed under the memo.
They give examples: safety of the public, safety of fellow employees, national security interest, or other compelling circumstances. Now, we have experience in understanding what a compelling circumstance is without identifying what that danger is. After all, we're dealing with an employee who was employed for 6 years after the events in question that are being relied upon to summarily dismiss him. He continued to function in the record shows in an exemplary way. So if you're going to remove him without any opportunity to be heard at all, cite an exigency. Tell us why he continues to be a danger to the public. It doesn't happen. They don't say a word about it.
If you're right about that, then they didn't give him the process that the memo says they were supposed to give him.
Well,
You're not arguing violation of the memo.
no.
The memo's procedural
No.
protections.
No. We have
You have to argue that the memo limits the grounds on which they can fire him, substantive grounds.
That's correct.
And that's what I'm not seeing.
Well,
You're saying there's a line between types of process.
Sure. Well, we have something called constitutional minia. What is a constitutional minia? Just simply notice and an opportunity to be heard, which differs from the process that's defined in the free memo.
Only if there's a protected property interest.
So I'm arguing that and it seems to be almost like an oxymoron with free memo here, which says that, look, we could summarily remove you. You're an employee at will only if you're a danger to the public. I mean, that's what they seem to be saying. And how do we reconcile those two concepts? We can't. So show me that you're a danger to the public. Give me, under the Fifth Amendment, give me a due process and opportunity to make a pitch, to claim I'm not a danger to the public. Give me an hour, bring me in a conference room, do something to give me an opportunity to make that argument.
Would this case be different if they explicitly stated one of those reasons as to the firing?
Well, substantively, they do. What they say is, they do say,
But I mean, I'm trying to get a sense of, you seem to be asking for more detail. Like, in other words, those are categories, but you seem to be asking for more detail, and then maybe, is this different in that regard?
no, they could tell me, hey, you're a danger. They could say something, you're an imminent threat. They could say, which is what this provision provides. They could say that you're a national security risk. They could say anything they want. I don't really care too much about that. What I care about is I just have an opportunity, because what's the objective expectation of someone like this? I cannot be summarily fired unless I pose a threat. That's really what
But
he's thinking.
I can be fired for any reason.
It doesn't say that. If it did, I wouldn't be here.
He's an at-will employee.
If it said that, if it simply said, which is what it really should have said, I could remove any.
Suppose they want to fire him for a reason that's not compelling and exigent. He's
Then
just
they have to-
he's a B+ employee instead of an A+ employee.
They got to follow.
They can do that.
They have to follow the rules.
This memo does not restrict their ability to do that.
Oh, I beg, Your Honor, I beg to differ. If they want to fire him for a non-exigent reason, they have to follow the rules. Give him 30 days notice, give him an opportunity to be heard, give him charges. That's what they have to do, because that's what they promulgated. That's the expectation here. So now they want to summarily remove him? Bye-bye. As you say, an employee at will, but it's fettered. It's not unfettered.
So, counsel, I understand your argument to be that the free memo's reference to exigent and compelling circumstances creates a substantive limit on how somebody can be summarily dismissed. But that language, how would you distinguish this case from Kentucky Department of Corrections versus Thompson, where there was similar language? It was a procedure that said visitors could be excluded when officials find reasonable grounds to believe that the visitor's presence in the institution would constitute a clear and probable danger. It sounds like that's a limit, but we held that it was not. It's not sufficiently mandatory. It doesn't sufficiently cabin discretion. And I don't see how this case is distinguishable from that case in terms of the specificity of the mandate.
Well, I would argue that when you're dealing with a level of reasonability, that is, difference between what is reasonable under the circumstances versus what is exigent, or what is a safety to the public threat, or
Well, this one says a clear and probable danger to security. Seems similar.
well,
We said that's not enough to create a property interest.
well, I would argue in a case like that this court, though, has issued other decisions, which seemingly are inconsistent with that.
Like,
Looking at the, very quickly. But I looked at Block v. Powell, and the Tarpey Court, which ruled that if the statute leaves a benefit to the discretion of the government official, no protected property interest. I'm not familiar with the Texas case, I'm sorry. However, Um,
It's a Supreme Court case. just
Right,
so-
okay. I understand. Thank you. Point is, Supreme Court has also ruled in Webster v. Doe that if there is a, what I call meaningful substantive standard, a meaningful substantive standard, that conditions summary dismissal, or that conditions discretion. I'd have to look at the Supreme Court case to see whether they consider that to be a meaningful standard, but that's what the Supreme Court said in Webster v. Doe at 486 U.S. 592. I don't see how we can distance ourselves from a meaningful standard in these
so
cases here.
How is it a meaningful standard? Like, how would we review a decision that something's
Well,
exigent?
is he a danger to the public? Is he a danger to the public? Is he a danger to his fellow employees? Is there a national security interest at stake here? And I'm not even asking this court to make that decision. I'm just asking for a remand back to the employer to give him an opportunity to make his pitch. That's all I'm asking for. I'm not even asking for judicial review. Now, it's possible that the Supreme Court case you cite forecloses judicial review. I understand that. But I'm asking that only his employer be given the opportunity, he be given the opportunity before his employer. I'm not asking for this court to make that decision. I'm asking for his employer to make that decision. I'm just asking for a remand. That's it. Give me my hour. Give me my half hour, whatever it is. But I think that Texas court actually was talking about whether a judicial review was foreclosed or not. I'm not asking that.
We also have another DC Circuit course, Ashton versus Civiletti, albeit 1979, but it's dealing with an FBI employee handbook. And in that handbook, it was ambiguous, and so then they offered the property interest in that regard, in terms of the language overbroad in that regard.
Yes.
So I kind of look at this case as any employment at will case allows for a person to be fired for any reason, good reason, bad reason, no reason.
Right.
Unless there is some mandatory language or broad language that requires there to be discretion in either a progressive discipline policy or things of that nature. And so, back to Judge Pan's question, and even Judge Katsas, about these limitations. If you don't have some absolute mandatory limitations on that process, then how are we to believe that there is such a cause of action available to you?
I think the standard, as I understand it, is it objective enough for an employee to believe that he or she would have an expectation that they would not be summarily fired in the absence of a threat?
Where are you getting that standard? I've not heard that standard or seen that standard cited anywhere. My understanding is the standard is
Right.
that the source has to have explicitly mandatory terms or unmistakably mandatory terms that cabin the discretion of the agency.
I could locate it. I could locate it. I've seen it. But I believe that is the standard. I'll find it when I get to my rebuttal, Your Honor.
All right,
How's
that's
that?
fine.
Okay.
But then I'd like to move on to your liberty interest.
Yes.
Okay.
It seems to me that your liberty interest arguments hinge on an allegation, there has to be an allegation, that the government, the agency, the employer has disseminated the information about
Right.
the employee.
Yes.
And I just don't think that's adequately pled in your complaint, or can you point to where it is adequately pled?
Yeah, I would say that the most concrete example of that is the CNN report that was actually cited by the.
But we don't know who gave that information to CNN.
We don't, but is it fair to the appellant at this early stage dismiss a complaint without perhaps the benefit of some discovery? That would be my only claim in that. I mean, you're right. We don't know the source of that CNN report that actually names him as the individual that was responsible. He was fired, and no comment. But I think that he should be given the opportunity to obtain some discovery. After all, it is an allegation. If it's true, and all we have to claim is that the government was the source of that information, he would have a cause of action.
It seems, though, that there could be many different sources for that information, and it doesn't seem fair to conclude that it was more likely than not
Right.
the government, right?
I'm with you on that, but all I would say is that I think it's just premature to dismiss a complaint without giving him some opportunity to engage in discovery, and then a motion can be renewed at some later point. That's my claim on that situation.
The closest you have in the complaint is your allegation that the defendants published through official channels these allegations for review by the public at large. Can you elaborate on that? Are we talking about the public release of the OIG report? Are we talking about naming the agent in the media, both?
Yes, naming the agent in the media in that CNN report. That is the only report that names him. The OIG
Well,
report was
there's actually
redacted.
more than that.
Yeah, okay, the
Ask
agent,
your opponent about that.
the OIG report was redacted. People would be able to figure out who these people are very easily. They refer to him as a supervisor in some reports. They name him in other reports. It's quite clear who he is. So the stigma's there.
You didn't plead. The OIG report names him as a supervisory special agent in the Indianapolis office. It gives some other details, supervised the Violent Crimes Against Children Squad, talks about when he joins the Bureau, talks about one of his prior jobs. I assume you all would know this, but the complaint doesn't have any elaboration on whether that set of descriptors would clearly identify him.
Understood. Actually, it was the respondent who's supplied those descriptors. And that just goes back to my point that they're in the best position to know.
Well, I mean, I assume your client knows how many special supervisory agents there were.
Well,
in
no,
Indianapolis.
if that's the point, I understand that, yes.
I mean, right, if the report, if there's a report that says the 40th president of the United States did something, we sort of know who that is, but.
No, I understand. But those descriptors came from the respondents. It didn't come from my client. So it came from the respondents. They actually articulated all the various news articles. They put it in there because they wanted to show how horrible he was. Okay, I get it. But by doing that, they've made my point that, he's been stigmatized. That's all. And I just want the opportunity to do some discovery on that so we can flesh out the record. I just think it's premature right now at the complaint stage.
On your stigma theory, not reputation plus, but stigma, our cases seem to say that you have to plead that the plaintiff sought alternative employment and couldn't obtain it. And there's just nothing like that in the complaint.
Well, I think it's clearly implied that when you're under these circumstances,
It seems like an obvious inference, but you have to plead the elements.
I
and that's an
understand
element.
that, but I do believe that there's enough in there to suggest that he was hampered, not completely foreclosed. And I think it's clearly obvious that hampering is associated with this stigma because it had reached public contempt in the news. He was stigmatized. Okay.
One little issue, only because I would ask the defense to respond to this. We're here on a motion to dismiss. I'm trying to cabin everything to the complaint, which is sufficiency of allegations and/or whether or not any such cause of action exists. And at least with respect to the liberty interest, it appears that the district court assumed without deciding that there was a liberty interest, but then decided that there was adequacy of the process.
Yes.
And so do you want to speak to whether
Yes,
or not
very-
that kind of went to the merits?
Yeah, very quickly. The process that the district court was referring to was the fact that he was the subject of an Office of Inspector General investigation. He sat for 2 interviews, and he was questioned about his role in this matter. The fact that you are responding to fairly and tailored questions in an investigation does not rise to due process. Simply responding, he doesn't have the opportunity to see what the charges ultimately are. He doesn't have an opportunity to see all the statements that back up these various
And I guess
charges.
my question goes to whether or not at this stage, all of that should be considered, because we're on a motion to dismiss.
That absolutely, absolutely, because simply responding to questions in an interrogation in which you're compelled to be there certainly doesn't, in no way can inform him ultimately of the basis for their claims and the merits or the veracity of the statements that are being made against him. He doesn't know. He's just answering very specific, narrow sets of questions that the OIG has an agenda, not a bad agenda, an agenda to ask. What does he know?
Assuming we reach this question, why isn't it sufficient process that he was shown the draft OIG report and had an opportunity to comment and respond?
Well, what he was shown is simply summaries. He doesn't see the entire set of statements. He was only shown what
Was he shown a draft of the report? I could be wrong. I thought it was.
No. He was shown only the summaries. The OIG agent summarized various statements that were made. But he was shown that. But again, at the time,
I mean, but if you're talking about the level of process required to justify a termination, right, assuming a liberty interest. I mean, it's not criminal process. I don't know of any cases that say he has discovery rights. It's just notice and an opportunity to be heard.
right, but he's making his pitch only to the Office of Inspector General. He's telling them, first of all, he's already, the OIG agent has already synthesized and summarized this information. We don't have access to the actual signed sworn statements. We don't have access to any of that. And we're not making a pitch to a deciding official.
Hasn't the government waived any argument in this regard by not defending the process on appeal?
Has the government waived it? They have not defended it. I would agree. Doesn't seem to be an issue.
And just to be clear quickly, the CNN report's not in the complaint.
No, it's not.
Okay.
Nope, it was in the motion to dismiss. I only reiterate the one point. I just think it's premature to dismiss the liberty claim for that reason. Okay.
Okay, thank you. We'll give you some rebuttal.
I appreciate that. Thank you.
Mr. Sturgill, you're up.
It please the court, Lowell Sturgill from the Department of Justice, representing the government. While the FBI has chosen to provide its employees with due process protections,
Can you maybe lower the mic? Not coming through clearly.
hope that's better.
No.
Time will tell, I guess. While the FBI has provided its employees with due process protections, it has also reserved the discretion to act summarily and dismiss employees summarily. And the reason it needs to do that is in order to maintain public confidence in the work of the FBI and to protect the public. So in this case, the free memo itself uses discretionary language, and it fully reserves that discretion without creating any substantive limits. A couple of points on that are helpful. First, a term like compelling is not itself explicit enough, and the test here from the court's cases is whether the language in question is explicit. So a term like compelling is inherently not explicit enough to create protected property interest. But beyond that, if you look at the language, there's discretionary language even in describing compelling. Free memo says consider compelling considerations if it may be compelling. So maybe is clearly discretionary language.
So it seems like your position is that the words extenuating or compelling, all those qualifying words do no work at all. Is that correct?
So first of all, they're not specific enough to limit the discretion of the FBI for purposes of determining whether there's a protected
So
property interest.
if I'm the FBI director and you work for me and I just don't like your tie, it just really bothers me, it offends me, and I say, this is extraordinary and compelling, and you're fired, is there any recourse to you?
So there's no protected property. And the employee couldn't say, I deserve some kind of opportunity to make a case for you for why this is.
So
not
there's no
protected.
recourse
There's no recourse.
at all? If you're saying there's unfettered discretion in the FBI director or assistant directors and above to determine what's an extraordinary or compelling circumstance.
Well, the employee can bring a Title VII suit or some other kind of cause of action. But what we have in this
Well, what's
case,
the protected class of people who have ties that the FBI director doesn't like?
well, it may be that that would not create it, that would not support a Title VII action. But again, these are at-will
So
employees.
your answer is
and
there's
they-
no recourse to somebody like that. The FBI director or assistant directors and above can fire somebody for any reason or no reason at all if they characterize the reason as compelling.
So that's the way it is with all at-will employees. They can bring Title VII actions, but if they don't have a Title VII action, you can't bring a complaint unless you either have a statutory cause of action or a constitutional one. So I think in your hypothetical, there wouldn't be. But again, I
So
think,
those words do no work.
well, they certainly, first of all, they guide the public in understanding what the FBI is doing and what the purpose of all of this is. So they serve that purpose. And then I think they would help the FBI understand what this is all about and how it should use its authority. But does it actually limit that authority? No. In Torpedo, for example, this court said that where an agency reserves discretion and doesn't require itself to explain the reasons for what it's done, then there's no protected property interest. And that's what you have here. You have language that goes out of its way to reserve discretion for summary dismissals. And nothing in this language requires the FBI to give any reason whatsoever for summarily terminating an employee. So under Torpedo, that is the end of that claim by itself. And also what I mentioned in the Crooks case, this court held that a standard that was an agency could terminate somebody for the best interest of the program. Well, that was deemed not explicit enough to create a protected property interest. And that's really, you have something very similar here when you have something, language like may be compelling is extremely broad. So for all those reasons, we think it's clear that the free memo expressly reserves discretion for summary terminations and definitely doesn't create any kind of explicit
So you
substantive
indicate
limitation.
allows this unfettered discretion, but yet it also has the limitation of the categories. How do those two match up?
So those are not, the key is, as the court, I believe, talked about before, are these substantive limitations that cabin discretion. And here they don't, because first of all, again, as in Torpedo, if you had something like that, then that would only cabin discretion if the language said, okay, well, FBI, you have to actually explain to the employee why you fired them. So there's nothing like that here, leaving it completely open for the FBI to engage in this kind of summary dismissal.
What is the discretion that has to be constrained? Torpedo says a significant limit on substantive discretion. Is it the discretion to fire him or the discretion to fire him summarily? So I think there probably is a judicially enforceable limit on the discretion to fire summarily. Safety to the public, fellow employees, national security, other compelling considerations. I mean, it's not the brightest of lines, but it's a high bar. It's language. Compelling is a term that's judicially enforced throughout all of constitutional law, right? It doesn't seem unmanageable.
Well, first
I mean,
of all,
but the problem I'm having is even if he gets over that hurdle, it just means he gets more process. But at the end of that, he can still be fired for any reason, at least within this memo.
so that's correct. The memo sets out process, but doesn't require a particular result. And was the case in the Kentucky case, I believe, where the court in the prison context addressed terms like public safety and prison safety, but said that that didn't create a protected liberty interest because it didn't go to the next step and say, okay, well, if you fall within those categories, then the government has to.
That one said if you fall within the category, you may be excluded from the prison, right?
But it also.
Something like that. And
Right, but it also contained, the Supreme Court held that elsewhere in the relevant provision, the provision included terms that were discretionary and made it clear that there was not something that had to be done at the end, even if it fell within one of those.
This one is of the form, you may not be summarily terminated unless some predicate is met. And the predicate is public safety, national security, or other compelling considerations.
So looking at the language, at page 13 of the appendix, which
Right.
you're at, first thing is, again, it says, I think this is really important. It says, when it's identifying these specific considerations the plaintiff says are explicit, it says other compelling interests that may be at stake. So it's not even saying, oh, if you can show a compelling interest, then that's a substantive limitation. It's as wide open as it could be. Basically, okay, anything that even could be a compelling interest. Well, that's not something that you find in constitutional law or anywhere else that you would address. So it's not like you can just map a free exercise claim onto this language because it's not the same. And that wouldn't make sense anyway, because again, the whole point of doing this is so that the FBI can act when it's necessary in its judgment to maintain public confidence in the agency. And here what we have
I'm
was.
not sure that's a fair summary of the whole memo. I mean, the principal thrust of the memo is to codify a set of procedural protections that are the default rules for terminating FBI agents. And this is the exception for extraordinary cases.
Well, again, I'm repeating myself, but I think if this language, this discretionary language had went on to say, okay, well, here are some public order, compelling interests, some other unidentified concepts, and you must then explain to the employee what the grounds for the summary dismissal were. Okay, that would be very different. That would be like in Torpedo, but you don't have that. I think the mere absence of that is enough to take this case out of the protected property interest category. But even if it doesn't, again, Crooks said that language saying best interest to the government is not sufficient to create a protected property interest. And I don't see how something that may be compelling is really any substantively different from best interests of the government.
Now, the district court assumed that there was a existence of a liberty interest, but doesn't really actually analyze, those allegations in that regard. So then we kind of skip to that there was adequate process, but we're on a motion to dismiss. So talk to me a little bit about whether that went a little further than it should have. Also, because I believe that you all stated you don't want us to decide that. So give me an opportunity to kind of explain the two.
Sure. So as our brief explains, we think it's a better practice for the court not to address the issue of whether Langeman's two compelled OIG interviews, provide him all the process that he was entitled to, and that's for a couple of reasons. First of all, we say it's has to do with the independence of the Office of Inspector General. So by statute, that office is separate from the FBI, and what it does is what it did here. It conducts investigations, and then it issues reports, and it notifies the employing agency of what those results were. So then it's the employing agency's job to take any act, to decide independently whether any employment action is necessary. So we think that separation is a reason for the court to not address this and to just address the case on the grounds that we've given you.
You're being a little coy with us, so let me just ask you directly. Suppose we think there is a liberty or a property interest. We then must reach the question whether the district court was right on sufficiency of process. Are you confessing error on that, or do you want us, are you defending it as a, next best alternative ground for you to win on appeal?
So we are not confessing error, and we, again, are just asking the court not to reach the question.
Well, then you're putting us in a pretty tough position, right? If we disagree with you on the threshold issue, we must decide that question, and you've given us no help.
Well, Your Honor, we have, the department and the government has carefully considered this question, and it's come up with the position that we are not prepared to defend the district court's, the grounds for the district court's judgment. So,
And you've offered no alternative ground to uphold a finding that the process was sufficient. So
that's correct.
in other words, if we think there's a property interest, you lose this case on that ground.
Well, we wouldn't lose the case. You would remand to the district court. And
Well, you lose the appeal. Sorry.
You lose.
It's a remand.
you would remand at least
Yes.
to the liberty interest claim. And we're prepared to deal with the consequences. That's
So,
it is.
sorry, then you're not asking us to affirm on the, I understand you'd rather us affirm on the ground of no liberty or property interest.
correct.
If you lose on that point, would you rather have the remand that Judge Pan posited, or the possibility of an affirmance on the ground stated by the district court?
So the remand.
Remand.
And that follows from the proposition that we have asked the court not.
Well, you asked us to decide the other ground as a preferable ground. You don't want us to decide that?
Correct.
Okay, understood. I appreciate that, and I know it's not your call, so thank you.
Thank you. So, I'm sorry, go ahead.
Now, I was just going to go to the merits of the liberty
Thank you.
interest, unless you had a, let's talk about reputation plus. The allegations in the complaint are pretty thin, right? But there is a general allegation that the defendants published, there's no question they terminated him. And then the plus is the defamatory statements, the allegedly false statements that harm him. And there's no question they released the OIG report. And they say they published through official channels for public review that he's the agent.
So we have,
I mean,
I'm sorry, go ahead.
no, go ahead. I mean, we have lots of contemporaneous reports of which maybe we can take judicial notice. Your friend on the other side says just the CNN report. There's actually a lot more than that. There was a Senate Judiciary Committee hearing at which the director of the FBI named this agent as the special agent in charge, subject to the, who was discussed in the OIG report.
So the plaintiffs have not relied on that report, and I'm not aware of it. So they've waived any argument that would be based on that report. And the complaint itself does nothing more than give you the threadbare recitals of the elements of the claim. And Iqbal clearly says that a plaintiff does not get to discovery merely by reciting the elements.
The plaintiff, the allegation in the complaint is that the defendants published through official channels all of these allegations against him. If the FBI director named him before the Senate Judiciary Committee, would that count as publishing through official channels, the
So-
allegations against him?
Right, it wouldn't because under the O'Donnell case, this court held that in order to state a reputation plus claim, the alleged defamation has to occur at the same time as the adverse personnel action. And the court made that clear that that's a requirement. So here,
He was fired August 31, 2021, 5 years after the underlying events, 2 weeks before the Senate Judiciary Committee hearing at which the agent was named.
so under O'Donnell, that
Don't think
timing
that's
is,
contemporaneous enough?
no, it is not, Your Honor. With respect, it's not.
Okay.
Because what O'Donnell says is that, of course, a mere allegation that the government has harmed somebody's reputation is not enough to state a constitutionally protected liberty interest. So what's required is some adverse employment action with that. And what O'Donnell says is that in order to get the plaintiff over that high hurdle to show an adverse employment action and harm to reputation, it has to happen at the same time. And the district courts in this circuit have taken this seriously. The McGinnis case, cited in our brief, said the same thing. It took the court at its word and said it has to happen at the same time. And O'Donnell says, again, it's the combination of the two at the same time that creates the kind of stigma that is actionable. So you don't have that here, even under the facts you've alleged, and I think that is enough to defeat their liberty interest claim without
But is
more.
that the only opportune time? In other words, if Mr. Langeman is applying for employment with another federal agency, would this information be available to the federal agency and therefore create some later in time potentially actionable claim?
So my understanding is that would not change the facts, is that what you look at under the case that's under O'Donnell is what is the alleged harm to reputation? What's the alleged public dissemination? When did that happen? When did the adverse personnel action happen? And what's alleged here is that he was dismissed. And did those happen at the same time? And that's all.
But
that's
you
as far
also
as-
state in your brief that he has not alleged that he actually applied and was turned down an opportunity. So how does that square with what you just said if you're trying to suggest that you only have one opportune time, which is the time of the firing, that there was some type of defamation?
So interesting question. He hasn't alleged that, let's say somebody came in and alleged, or he alleged that, yes, I applied for a job down the line. And guess what? The FBI publicly defamed me at that time. So then the question would be, is the denial of a job based on that enough to create protected liberty interest? He hasn't put that at issue in the case, so we haven't briefed it. And I'm not prepared to tell you what the answer would be this morning because of that. But again, he hasn't argued it, and you don't have to address it because he hasn't said that he's applied for a job. That's the best I think I can make of that.
Can we infer the stigma? We've talked about reputation plus. Stigma is about what happens later when he applies for other jobs. You know, on the one hand, that is an element of this strand of a liberty claim, and it's not in the complaint. On the other hand, they fired the guy for these extremely serious allegations leading to 70 young athletes being molested. I mean, he's never going to work in law enforcement again. That seems blindingly obvious. Can we draw that inference?
So I don't believe the Orange case, which is the key case, creates any kind of what might be a futility exception to the requirement that somebody has to show that they've applied for a job and been denied it. So I think that's sort of the end of that. That's a bedrock requirement that he's got to plead and show, and he hasn't. And again, Orange is the key case. And the plaintiff uses the word hampered in the complaint, but this court's cases also say clearly that some stigma is not enough to create a protected liberty interest. So hampered sounds a lot like some stigma and far less than what a plaintiff has to plead in order to get over the high bar to show this kind of liberty interest. I believe that's all I have. We're happy to ask.
I'll let you wind down if you want, just briefly.
We would just ask the court to affirm.
Thank you.
Entitled to retain the benefit. And my only point in that, in the property interest claim, is that, and my intuition says that in that Texas case, someone who wants to visit a prison, I don't believe has a robust enough property interest because it's so transient for an objective observer to believe that that is a protected interest. But a civil servant who's earning his income and has potential eligibility for pension would have. A reasonable person would say that he or she has an objective basis and an expectation that he or she will continue employment absent, or at least have access to due process absent exigent circumstances. And that's how I would distinguish those two situations. And I believe my client has that for purposes of the property interest. And my last point concerning liberty is that when you're stigmatized and your reputation is affected by claims of dishonesty in the law enforcement community, you're kaput. There's no further potential for employment as a law enforcement officer.
That sounds right, but you didn't plead it.
Thank you.
Thank you.
I appreciate your time. Thank you very much.
Thank you.
The case is submitted.
Case number 22-5153, Amara Emuwa et al. Appellants versus United States Department of Homeland Security. Mr. Cleveland for the appellants, Mr. Pfaffenroth for the appellee.
Mr. Cleveland, good morning.
Good morning, Your Honor. As we approach this case, two things are important. Harm, trial by ambush. Asylum applicant seeks asylum, he must show harm. Consider the case of Mr. Fon, F-O-N, from Cameroon. He was beaten, stabbed, a 3-inch scar. They ransacked his house. He had to go into hiding. He lost his job. My friend at DHS saying not enough harm. Trial by ambush. DHS says that's okay. Of course, they mean we can do trial by ambush, but not you. It is legal for DHS to ambush an asylum applicant in court with the entire assessment. That is unfair. And they do not claim to suffer harm when they introduce the entire assessment into court. When they do that in immigration court, they're revealing it to the applicant, his lawyer, the immigration judge, and whoever else is sitting in the courtroom. Do not claim harm at that time. notice of intent to deny. I'm holding one in my hand that you have from the Boston Asylum Office.
Do you know how often they actually use these documents in a hearing or disclose them in a hearing?
Not very often. It happened to me in March of 2016. I don't know statistics. They, they claim the right to do it, and
If it's not very often, then we can't draw much of an inference undercutting their theory of harm if they do it once in a blue moon.
well, it undermines their claim of harm that the assessment is top secret and release causes harm. The fact that they release it voluntarily is evidence that it's not causing harm. I agree, the more they release it, the more evidence there is of lack of harm.
So their claim of harm is that this is an internal document, it's deliberative, and if the writers of these documents know that it's going to be disclosed and made public, that will chill their ability to be frank and candid in creating the document. And it seems to me that the fact that every now and then it gets released in a hearing would not be sufficient to chill it. But if it were released as a matter of course in FOIA requests, that would chill their ability to be frank and candid.
Well, they do say that, which is a mere repetition of the generic reason behind the deliberative process privilege. But it's their burden to show harm. The more they release it, the less harm that there is. There is no expectation of privacy of asylum officers. Asylum officers are instructed that many people shall read the assessments. The applicant, the lawyer, the immigration judge, the FBI, contractors, Department of State, and members of Congress. The APM says somebody makes a FOIA request for the assessment, it may be released. Anybody who reads that will think, oh, assessments are not top secret.
So these documents are covered by the deliberative process privilege, right? We've already held that, and it's obviously true. And they are recommendations from a subordinate to a superior, which Machado and Abtu both said are at the core of the deliberative process privilege built into Exemption 5. And the affidavit here checks the boxes that Machado says you have to check. It talks about the specific documents at issue. It says that their release could chill candid discussions. How are these documents, why is this case just not controlled by Machado?
The declaration in our case by Ms. Munita does not discuss the specific information. The declaration in Machado was written by a person inside the OIP. He did it for 10 years, and she has 41 paragraphs. She just describes things with specificity.
Could I ask you about this, counsel? Because it seems to me you've taken the position that the Munita declaration does not address the specific documents at issue, but it seems to do so. In paragraph 12, it talks about the withheld portions of the 4 assessments at issue in this case. Paragraph 13 says, in each case, the withheld information contains certain information. Paragraph 14, it says, revealing the specific deliberations from the assessments in this case would interfere with the ability. It seems to actually address the assessments at issue in this case.
There's generic language. She could use that declaration for all assessments. We don't, there's 4 assessments in this case with 4 different people. One lady's domestic violence from Nigeria, another lady is fleeing, she's a Mongol fleeing communist oppression. There's no evidence that Ms. Munita knows any of that. What is it inside these assessments that is so top secret that it can't be revealed? She doesn't tell us. It's a fill-in-the-blanks declaration. Someone told her, oh, asylum officers wrote a report. And then she says, oh, the contents of the report contain information, and release of that information will shill them. Consider the Army Corps of Engineers and electric power lines and the environment. Somebody writes a report and says, this report contains opinions of the officers about electric power lines and the impact on the environment. We reveal those things, it'll shill them. I could write the declaration for this agency. Yeah, this is insufficient. You can't just have boilerplate. Whatever is.
Could you address paragraph 15? Because that is not boilerplate. That's the paragraph that talks about if you provide this information, bad actors could take this information and tailor asylum applications in a favorable but fraudulent manner. That doesn't seem to be applicable to all different types of deliberative processes.
Well, I agree with that. That does. Correct. However, that statement itself is based on what?
Take paragraph 14, one paragraph before, revealing the specific pre-decisional deliberations withheld from the assessments in this case would interfere with USCIS's ability to make sound judgments, et cetera.
In this case, makes it look like she read the assessments. That's by boilerplate. What is it in this case that is special? We have 4 different assessments. You should consider the age, content, and character of each one. Otherwise,
Well, we've held it can be done on a categorical basis. We have not held that there's any requirement to review each document.
well, there is language in many cases. We shall reveal each document. Church of Scientology, that the CIA had 25 documents, and the court said, we approve of the declarant who said they discussed each document paragraph by paragraph. I think that in this case, especially since we have errors in the assessment, and we have the avoidance of other information, other contrary information, notice of intent to deny are revealed every day. I think that's a very important part of the case. Content of a notice of intent to deny is the same as the content of an assessment.
But the courts have held that just because you reveal it in one instance doesn't mean you have to do it in others.
Well, correct, you don't have to, but it undermines their claim of harm. Say, oh, we suffer harm if information from the assessment is revealed. That information is the same as in the notice of intent to deny.
That's a different kind of document, right? That is designed to be tendered to the alien.
It's a report about the alien's application.
But it's not deliberative.
It's an
It's
opinion
not
by-
an internal document. It's something that's created in order to give notice to the alien.
It's an opinion written by the officer about the applicant. You don't have, I say that the noids are exactly the same as assessments. You don't have to take my word for it because noids are in the record and assessments are in the record.
But they're not identical in the way that's important in this case, which is, would it chill the deliberative process?
If twin brothers come to America, and then they both had suffered harm in the old country, and one brother is out of status at the time of his interview, then the officer writes a report. The officer writes a report about both brothers. The reports are exactly the same. One brother happens to be in status, like he's a student, he gets the report.
But
The other-
your hypothetical assumes that the officer is going to write the same thing in a deliberative document as one that it knows will be provided to the alien. And I don't think that you can make that assumption.
Well, the officer does know that in many circumstances, the assessment to refer shall be revealed. The noise shall always be revealed, but the content is the same. I think that's important. Also, sources. Sources are important. What sources are asylum officers using? What if they're using bad sources? The public should know that. The case in the First Circuit, the asylum office used a criminal database, and the court said that's unreliable. Another judge cited Wikipedia. That's unreliable. What are our asylum officers citing as sources in their assessments? The public has the right to know. And the AAPM instructs officers, you must include at least 2 different assessments, 2 different sources in some circumstances when you write your assessments. Are the officers following their rules or not? That is the beautiful purpose of the FOIA, that we'll find out if the officers are doing what they're supposed to be doing. Another consideration is, agency says we suffer harm, we suffer harm.
Can I ask you a question about sources? Is there like a section in this report that lists the sources, or are the sources kind of sprinkled throughout the document?
They're sprinkled throughout the document, just like a judicial opinion.
That seems very laborious. Are you saying that in each case, the
Well-
agency is required to go through and figure that out and reveal
Well,
sources?
it's all that,
And you're not distinguishing between fact-specific sources like witness testimony and documents versus more general sources?
well, one source I'm interested in is like from the Danish Immigration Service. I'd never heard of that until I read it this annoyed. Well, if that's the source the asylum office likes, then that's good for the private bar. They can cite that back to the asylum office.
Doesn't that support their point that that will cause the private bar to tailor their applications to sometimes fraudulently address the sources that they know the agency relies on?
Well, but citing a source is not nothing fraudulent about that. It's good to cite a source that the tribunal likes, seems to me. This case from
But I
Boston.
think the argument is we don't want to reveal everything because then some people who might not be scrupulous could look at our sources and tailor their applications fraudulently.
Yeah, yes, but that is true of district court opinions. District courts write opinions and they cite their sources. Someone else could read that and say, oh, like the guy that
Sure.
the court has big boots to hide his crime. So that is a fear we have always. However, the countervailing proposition is we want transparency in government. Why shouldn't they reveal their sources?
The district court's final decision is made public and is judged on appeal or in the court of public opinion by whatever the judge chooses to put in the opinion. That doesn't mean that the judge's first draft or the law clerk's bench memo to the judge saying, speaking more candidly about the legal reasoning isn't deliberative, shouldn't be protected.
That's true. However, assessments written by the asylum officer is what is used in the immigration court to get them deported. And another,
Only if they choose to introduce that document, which they usually don't.
that's true, but it's used.
Right, you get, all of this is just about the executive's deliberation on whether or not to oppose asylum. And it eventually leads to an adjudication in immigration court, trial de novo. You can put in whatever evidence you want, and the government has to put in sufficient evidence to get the alien removed if that's what they want to do.
Well, that's true, but Congress said that agencies were overusing the deliberative process privilege, therefore, to hide it, to not reveal it, they must show harm. What is the harm? They've not explained that. Consider the history of DHS. In 1990, the regulation said you shall disclose sources, you must give them to the applicant. No claim of harm from 1990 to 1995. Then they changed the policy without saying they suffered harm. Then from 1998 to 2005, they released all of the assessments. No claim of harm during that time period.
How do you know that there was no harm? Maybe that's why they changed the policy.
There's no evidence in the record. It's their burden to show the harm. They don't even. And more importantly, May of 2022, now for certain applicants, without even having, the regulation says, without having to make even a FOIA request, the officer shall give the decision, the entire decision to the applicant. And also, all non-classified information considered by the officer shall be disclosed. DHS voluntarily adopted that regulation, saying, we're going to give you information that's not even in the decision. We're going to give you information considered by the officer, and it shall be disclosed to you. The fact that they did that is evidence that they themselves know they don't suffer harm. They're giving us information. They voluntarily give information that shows they don't suffer harm.
Thank you. Judge Giles, anything else?
Just a question about the other issues in the case, like segregation, whether they should reasonably segregate the sources. Should we even reach those issues?
Yes, we should. Yes, we should. And by the way, there's errors in the lower court decision. At 287, the judge wrongly repeats the Soley stuff, and at 387, the judge refers to the supervisory asylum officer. There are errors in the lower court decision, and they did not, UNITA does not mention sources in her opinion.
But were those issues raised before the district court is what I'm getting at, about whether we should reach them?
Yes, we always, at all times argued sources should be revealed. Sources should be revealed. But they've never talked about it directly. UNITA does not mention them in her declaration. That's evidence to me. It's not considered. I would suggest in the totality of circumstances, the lack of personal knowledge of UNITA and anyone else she talked to, and the errors in it, the history of the agency, look at it in totality, the agency does not meet their burden of proof to show harm. I would suggest the lower court should be reversed.
Thank you, counsel. We'll give you some rebuttal time, and we'll hear from the government now. Good
morning.
Pfaffenroth?
Yes.
Mr. Pfaffenroth.
May it please the court, Dr. Pfaffenroth for the Department of Homeland Security. My friend makes it sound like these proceedings where in front of the asylum officer are end of the process, but as Judge Katsas correctly noted, there's a trial de novo in front of an immigration judge that follows from this. Furthermore, as my friend acknowledged, these assessments to refer are only in the unusual case ever introduced in an immigration court proceeding.
Do you have any?
They're not part of the record.
Do you have any order of magnitude estimate? One case in 10?
I've asked, and I've been told it's very rare, but they don't quantify it. So occasional.
Okay.
And furthermore, my friend, to his credit, this area is a passion of his, and he's been looking for assessments to refer wherever he can find them. And this record in this case, including in the appendix, includes a handful. Those are the handful of which I am aware. Those are the handful of which my agency colleagues have told me they are aware that are in the public record. There are hundreds, if not thousands of them, right? It's not quantified, the record. But these are very unusual. And the fact that a handful have come out as an addendum to a Ninth Circuit decision or in a settlement in one specific case for a specific reason does not mean that the public at large can access a large body of these such that one might be able to figure out what needs to be said in front of an asylum officer in order to successfully persuade the asylum officer. We want the asylum officer to bring to each proceeding an open mind, to listen to the evidence, to give the applicant a fair hearing, and to make the best recommendation to the asylum officer's supervisor that that person can. And then the asylum supervisor makes the decision, but that's, as I said, not the end of the road. Then it goes to immigration court. And it's trial de novo. Typically, if these assessments to refer are introduced in immigration court at all, it's only as impeachment evidence, in which case, under policy and the law, the asylum applicant as well as counsel have the opportunity to review the evidence and to say, well, that's not really contradictory of what they've said today in front of the immigration judge. But these are, the main point is that
But go back to the
yes.
arguments presented by the other side about this could be just kind of a checkoff affidavit. And then all you need to do is add the words "in this case." And then that makes it somehow more specific to this case to get you beyond the reporter's comments case.
Your Honor, there are limited things one can say in an affidavit without showing what's really going on behind the scenes, right? This court has recognized that, for instance, in the Glomar context. Furthermore, in attorney-client privilege context, right? The facts that are essential to the the attorney's advice to the client, those are privileged under this court's jurisprudence. So the current practice and the established practice that the Homeland Security Department, USCIS, has stated it is holding to, as noted by this court in Abtu, that it is releasing, pursuant to FOIA requests, the factual part of an assessment to refer. What it is not releasing are the asylum officer's assessments. And that's for good reason, because we want to respect the candid advice, protect the ability of the supervisor and the asylum officer to interact and make the best decision for both the applicant and the United States, right? On the evidence presented to the asylum officer, does this applicant establish that that person is entitled to asylum? Or to the contrary, is this one of the many instances where people have applied for asylum and it's just not well justified? In which case, we'll let the immigration judge make the final.
Can you speak briefly about the 3 other kinds of documents that your friend mentioned? So let me just,
Sure.
I mean, on the one hand, they are just different. They're done for a different purpose. They're done in order to hand something to an alien to start a process. So I get that, but they do involve asylum officers assessing the strength of the case and jotting down their notes in some written formal way. And that material is routinely handed over and doesn't seem to have put the Republic in jeopardy.
I understand. They're just different, right? If I were a law clerk writing a bench memo for Your Honor, and I expected it only to go to Your Honor, I would be as candid in my analysis as I could. If I were writing a bench memo that was going to go to you, as well as to the Washington Post, it would read very differently. That luckily is not the world in which we live.
Are there other channels in the contexts where a notice of intent to deny, notice of intent to terminate, record of determination, in the context where those documents are generated, are there other documents that are deliberative where the officers are fully candid in the way that my law clerks would be?
Okay. I have to assume yes, but I'm not an immigration officer and I don't live in that world on a day-to-day basis.
And I asked your
Yes.
friend about whether we need to reach certain issues, just based on whether or not those were actually presented to the district court. I just wanted to know how far we should be going in this opinion.
Which issues do you have in mind?
Segregability was one of them.
Well, segregability was originally addressed in the initial ruling, which was before the initial appeal, and I don't believe that.
And the reason I'm saying that is because the remand said focus on the foreseeable harm.
Right.
Okay.
Right. And I think, furthermore, under precedent, if an appellant raises certain issues on appeal and doesn't really dwell on others or just leaves them, sort of in the footnotes, for lack of a better word, they're not properly presented. I don't think there's really a meaningful dispute at this stage of this appeal about segregability. He addresses sources, which, as I've already noted, are an integral part of the analysis, determining whether or not the requisite showing has been made. And in that sense, I don't think that you couldn't segregate out, any given source without, showing the underlying reason why that source is relevant, or at least giving a pretty darn good hint. I think the reference in our brief to the mosaic theory is applicable, right? I mean, it's if you let out a sufficient body of records, whether it's about FBI investigatory practices or what goes into a successful initial appearance in front of an asylum officer, there are many people who will gather all the evidence they possibly can in order to try to understand that process, in order to achieve the outcome we seek. But I don't believe the court needs to take a deep dive on segregability. Just make sure there's nothing else I wanted to mention. Oh, my friend mentioned a new regulation. I will not get into the weeds of that. I will simply say that that is for a very different context in which assessments to refer, my understanding, are not even prepared. Those are for individuals who have just crossed the border and been apprehended, and there is a special procedure that has been developed for that.
Sorry, which one is that?
It's in a footnote. I'm sorry.
It's not one of the three I mentioned.
No, it's not. Our response to it was simply it wasn't argued in the district court, and obviously the regulation too. Well, this matter was on appeal, or around when this matter was on appeal. Point is, it's just, and I don't think that the court really has the record in this case, nor would it be prudent to dive into that. I printed it out because I didn't look at the page count, and it was 2 inches thick. So anyway, or at least the federal district is. So if the court has nothing further for me, I'd ask that the decision. Sorry.
Okay, thank you.
When someone comes to America seeking asylum, they say, I suffered harm in the old country, I want asylum. And whoever they're talking to, asylum applicants talk in different contexts, but it's the same thing. I suffered harm, I want asylum. And under many circumstances, the United States will give them the decision of the officer. And only for this assessment to refer, they hold that one back. And ironically, that's the one that they hold it back, that they can later use against them in court and to ambush them. OIP issued guidance in March 2023. They say when the aspect of harm is unclear, then the agency should consult an expert. And that's what they should have done in this case. Ms. Munita got her job a few months before she wrote her declaration. She doesn't know anything about the asylum division.
But she was an immigration officer before she got this particular job. She's been working in this field for many years.
Doing other things, not asylum. Yes. She doesn't claim any knowledge whatsoever about asylum. What is the harm concerning asylum officer assessments? That calls for an expert opinion. And the OIP makes a suggestion that the agency should have done that. By the way,
She's the chief FOIA officer of USCIS regional office.
And she
That's
was an
true.
immigration services officer. Don't they deal with asylum?
No.
They don't?
No. She doesn't know anything about asylum. She doesn't claim to, and she doesn't claim she ever talked to anybody with personal knowledge. It would have been
What do
easy.
immigration services officers do?
Family petitions, employment. Asylum is an asylum division where all they do is asylum, and the rest of immigration.
And what are their titles in the asylum division? What are they called? Are they called asylum officers?
In the asylum division, they're called asylum officers. In the other division, they're called, I don't know what they're called, officers. They don't do asylum. I would suggest that it would have been very easy for the agency in this case to get a declaration from the asylum division, and problems would be solved. Very easy.
Do the field offices deal with asylum cases? Because she was a field office director.
There are now 11 asylum offices in the country. There's about 20 field offices. They're different. Asylum is its own division. It is very separate. Ms. Muniz's declaration has no personal knowledge. It contains errors, and she does not consider the age, content, and character of the assessments before her. So I would suggest her declaration is insufficient.
Thank you. The case is submitted.
Case number 22-1166, East Texas Electric Cooperative, Inc. et al. Petitioners versus Federal Energy Regulatory Commission. Mr. Rose for the petitioners, Mr. Kennedy for the respondent, Mr. Kaiser for the respondent intervener.
Whenever you're ready.
May it please the court. The four issues before this court concern the arbitrary and capricious FERC approval APUS manipulation of its formula transmission. Issue one is procedural, the remaining issues substantive. Issue one, challenge period. That breaks down to the two issues. What does the tariff protocol section 5D say in Packer-Harris? And two, what does FERC precedent say in Packer? Let's turn to the tariff.
Can I ask you a question about that before you proceed? Even if there were some longstanding practice of backwards error correction, do you agree that that could be superseded by the terms of the protocol?
The terms of the protocol has to itself be just and reasonable. Now, I appreciate that this is not a contract. This is a tariff protocol. And tariff protocols are judged on whether they are just not on whether parties agree to.
So, but you think that this case is determined by the protocol, Section 5D, and if Section 5D were contrary to a longstanding practice, if it chose to override a longstanding practice of backwards error correction, it could do that, correct?
It can do that.
So do we even need to think about what the longstanding practice is, or do we just need to look at Section 5D and what it means?
Well, the longstanding practice informs this court as to how FERC should be interpreting that tariff provision.
I see.
But on the other hand, you have not made an argument, and I don't think you could argue that enforcing time limits on this tariff process would be unlawful, right? Would violate the Federal Power Act. Your only argument is based on what FERC has approved in other cases.
That's correct. Anyway,
Which
going
sort
back-
of puts an exclamation point on Judge Pan's question.
and I'll explain exactly why that precedent FERC has is so important in interpreting the tariff. The first issue is, does the tariff protocol unambiguously bar backward error correction?
Well, it's actually whether FERC could reasonably construe the protocol to do that.
Well, you have to get past whether the language is ambiguous or not. If it is ambiguous, then you go to whether FERC's interpretation is reasonable.
So if you're within the range of reasonable disagreement, FERC wins.
No, it's not whatever FERC says.
You don't think FERC has interpretive authority over tariff provisions?
They have interpretive authority,
Okay.
but it has to be reasonable. And that Chevron type
If
2
we're
analysis,
in the zone of reasonable disagreement.
That is
FERC's
correct.
interpretation.
that is correct. And that kind of interpretation depends on looking at the text, structure, purpose, and history of the protocol. Turning to the issue of, is the protocol itself unambiguous? Looking at the APUS protocol section 5D, it speaks of challenges to current annual updates, future annual updates, and doesn't say anything at all about previous annual updates.
But weren't the
Yes,
previous, I'm sorry, but weren't the previous updates subject to Section 5D?
That's our claim that section 5D says nothing at all about previous annual updates.
So
Here's-
it talks
there's
about
language.
A given annual update,
Yes,
which would seem to cover 2018 as well as 2019.
no, it covers the annual update the facility has filed. Doesn't say anything about the previous annual.
But in 2018, Section 5D applied.
Yes, it did.
So
But Section 5
under that reading, then you had to bring challenges to 2018 in 2018.
No. The language itself talks about the language. Appreciate, we're talking here, all sections of Section 5D. It is talking about you have an annual update, you make your challenge to that annual update, and that does not prevent you from making other challenges that you missed.
But you should have made it into, doesn't, under this provision, shouldn't you have made challenges to 2018 in 2018?
No, that's not the right way to read the language.
Why not? Because this applied in 2018, so you had a chance to challenge 2018 errors in 2018.
Let me explain. There is language that would do that. You can find that in the Evergy, Kansas protocol, which FERC said was informative. It is informative, but not for the reason for the thing. The Evergy, Kansas protocol.
Let's just talk about this one. This does seem awfully clear. It talks about a given annual update with the indefinite article a and the adjective given. That doesn't mean the one and only annual update that is the most recent one under litigation.
A annual update means there's going to be a whole series of annual updates.
Right.
You know that in advance. But this language
And
refers
a
to the one
given
that-
annual update would seem to refer to all of them.
No. You want to get the series of annual updates. You use language like each annual update, which is what the Evergy protocol said. But that's not here. That language is simply not here. So if the court believes that there is a logical possibility of interpreting this language to not address backwards error correction, then at the very least, the language is ambiguous. If the language is ambiguous, then this court looks to see if FERC's tariff interpretation is just reasonable.
I'm sorry, we look to, I didn't hear you.
Oh, then we look to see whether FERC's tariff interpretation satisfies the arbitrary and capricious standard. If the court will look at
I'm
there,
sorry, counsel, I really want to understand your argument. So the language says, failure to pursue an issue through a preliminary challenge or to lodge a formal challenge regarding any issue as to a given annual update shall bar pursuit of such issue with respect to that annual update.
correct.
I don't understand your argument as to why you didn't have to bring up a challenge to the 2018 tariff in 2018 under this provision.
In 2019, that annual update was the 2019 annual
I
update.
understand that, but this also applied in 2018. So your
Only if-
chance to do that was in 2018.
Only if you make that assumption, but that's not in the language itself,
How is
What's
that
the
an assumption?
because you're assuming that that annual update goes backwards. Where is that language?
It says any issue as to a given annual update shall bar pursuit of such issue with respect to that annual update.
Yes,
So in 2018, any issue as to that annual update in 2018 should have been raised then. Failure to pursue it in 2018 shall bar pursuit of such issue.
no, it doesn't apply.
Why?
Because you're dealing with, and the language is clear about this, you are dealing with a given annual update and then its implications for the next annual.
That's for
update.
2019, but I'm saying you want to raise error correction from, for example, 2018.
Yeah.
But in 2018, 5D applied.
Yes, it did. And for 2018, whatever challenges we made applied then. But you can always find errors later on and apply it backwards to 2018
I don't understand how the language allows that.
because it does not address backward error correction. It simply doesn't say that. There is language that can address backward error correction, but they didn't use that.
Well, how does Section 205 and 206 of the Federal Power Act play into this then?
Well, let me explain it this way. With stated rates, the utility must wait for the commission's decision to change the rate. The cost of service formula rate, the utility changes its rates. Then the commission takes a backwards look to make sure that the final rate tracks the actual costs of the utility. There's no good reason to limit the backward error correction. That's a Section 205
Why not?
type of proceeding when
Why
you have a
not?
formal challenge.
Why not? I mean, there are strong anti-retroactivity principles built into the statute.
That would
It's a
be true.
5-month period built into 205.
That would be true for the formula rate, which is the formula itself, which is the rate. But it is not true for the data inputs. Those are never approved as final. You can always bring, and FERC will admit it, a 206 case with backwards error correction.
And 206 has anti-retroactivity principles built into a refund period. I
Take a
mean,
look at,
it's just very odd that for this little kind of process that's sort of in the gray area between 205 and 206, you can go back to the beginning of time when under either prong of the statute, you can only go back so far.
well, it's not so odd, even according to FERC. I mean, since the days of fuel adjustment charges, FERC has explicitly allowed in case after case error correction and prudence challenges. They go back to when the error first appeared and at whatever time the error or imprudence was discovered.
Can you explain, maybe it's just my lack of familiarity with FERC, but why is this claim properly brought under 205 instead of 206? Because it seems to me to be a procedural overarching thing and not about specific things.
We have there is a formal challenge process to a rate. And the formal challenge process is 205-like because the utility has the burden of proof to justify its particular cost of service, its data input.
But the claim seems to be that there's a procedure going on about backwards error correction that you think is not fair and just.
That is
Shouldn't that
correct.
be brought under 206?
No, that would be a challenge to the formula. We're challenging the right under the protocols themselves to make a backward error correction.
Okay, so if we interpret the protocols to be unambiguous and to favor FERC's interpretation, if you wanted to challenge that, then you could bring it under 206.
That's correct.
Okay.
Appreciate, however, that FERC's position, if they're right on Section 205, on Section 5D, that would apply to both 205 formal rate challenge and to 206 challenges.
Oh,
Yes,
why?
for data input, because it's barring backward error correction, which is what FERC would argue. It bars backward error correction for both kinds of challenges. Yet you have this extensive FERC precedent that, yes, you can make backward error challenges under 206. You just wipe that away.
So is it correct that all the precedents would be relevant to a challenge under 206 to say this is just not fair and just the way you're doing this?
Yes.
Okay,
When you
but
get
they're
down-
not really relevant under this 205 challenge because we're just interpreting what 5D means.
If you decide that Section 5D is unambiguously barring backward error correction, then what is relevant is only that the 206 challenges seem to have gone away as well. And that's just not correct.
So this would be a precedent that would govern a 206 challenge? Is that what you're saying?
Why?
Yes, this 5D protocol language is used throughout the industry. It's based on the old MISO protocols, the big FERC inquiry into the justness and reasonableness of how you do transmission formula.
But that doesn't mean that you can't challenge it under 206.
We
Does
could,
it?
we could challenge the formula under 206, but the data inputs, we could never challenge again,
But it wouldn't be a data
even under a
input-
206.
I'm sorry, I just want to make sure I understand this. If we think that 5D language is unambiguous, in this case under 205, my question was, can you then raise a challenge to this procedure under 206 by saying it's not fair and just? And I thought your answer was yes, but then you said that your 206 challenge would be governed by our reasoning in this 205 challenge, and I don't understand why.
I'm distinguishing between a 206 challenge, the data inputs, errors in data
But
input.
your 206 challenge would not be to data inputs. It would be on the procedure of backwards error correction being limited.
That's the second, that's the other aspect.
And that
Yes,
would not be governed by the 205 decision we make in this case.
correct.
Okay, thank you.
206, FERC says parties have a degree of ability to limit backward-looking challenges under the tariff protocols. And they say that does not, that is okay if and only if 206 challenges are unlimited, correct?
The 206 challenges to the formula rate, you can always formula itself, and then you can always bring a challenge to the data inputs and get backward error correction for the data input. Successful challenges to the formula are prospective only.
I thought challenges to the formula could be retroactive. That's the 206 challenge.
No, if it's a challenge to the formula, that's prospective, and you win, that's prospective only. The data inputs are not part of the formula, they're just data input,
Okay.
and that you get backward error correction for.
Okay.
Yeah, but
That was not my understanding of 206. I thought the backwards error
205,
correction.
205 and 206 both have within them challenges to rates and to classifications, practices, and regulations affecting such rates. My understanding is all of this, all these protocols are implementing statutory language about classifications affecting rates under 205.
Yes.
None of that addresses your ability to use 206 to challenge not only rates, but classifications affecting rates.
I'm not sure what you mean by that. You're talking about section 205?
Talking about, yeah, whatever we would say in this case about the permissibility of this kind of time limit in the tariff protocol. The tariff protocol can require you to challenge the inputs year by year, correct?
Yes, it specifically allows you to challenge each annual
Well, require you to do it year by year.
Yes. Well, they have to file it year by year. Yes.
As a challenge to the classification affecting rates under section 205.
Yes.
I guess I'm just not seeing why that bars you from invoking 206 to challenge the classification.
Well, if you read the language as FERC does, that it applies to all, the bar challenges applies to all previous annual updates, that knocks out a section 206 challenge to the data inputs. And that's contrary to FERC precedent.
But not if your 206 challenge is challenging the formula and
That's
the
correct.
protocol as applied. So my understanding is, correct me if I'm wrong, you have challenged the application in this case, section 5D, that protocol. If we decide that section 5D is unambiguous and it means backwards error correction is allowed under section 5D, you could go under 206 and say, I want to challenge the formula and the protocol, not the application of it, but what it is, and say it's not fair and just. And in that case, you could have a separate case that challenges not the application of it necessarily in section 5D in this, or actually it is, not in this case, but generally speaking, the way we've interpreted is not fair and just, and so you want to overturn the protocol, and that would be under 206. And my understanding was that you could get backwards error correction under 206, because there are a lot of cases that seem to say that, but you're saying you couldn't get backwards error correction under 206? Because if in 206, you were able to get a holding that this provision, which we've held to be unambiguous, is not fair and just, you could then challenge the provision that way, and then you could get backwards error correction because the formula, as it was written and as we've interpreted it, was not fair and just. Is that correct?
No, the change to the formula, that all proceeds as you describe it, would be prospective only.
It would, okay.
And then we could start making backward error correction arguments if we won that issue subsequent.
Under 205?
That's what we would win if we won on challenging the protocol.
If you succeeded in challenging the protocol under 206, then you would file backwards error correction under 205 based on the new interpretation of the protocol?
Yes, it would be 205 formula challenges.
Okay, I see, because we would have held in that instance that you could backwards correct, because that was not fair and just. So you would
Correct.
then go under 205.
I had the same question you did, and we found an opinion putting this stuff under 205,
Okay,
what's happening here. But
thank you.
Are there any more questions?
Not on this issue.
thank you. We'll give you rebuttal. Hear from FERC.
Good morning, Your Honors. Robert Kennedy on behalf of the Commission.
Can you just walk us through
At the risk
the
of,
mechanics of this? I mean, I look at 205 and 206
so,
and see what I see. You all seem to conceptualize this, this process for challenging inputs on the backward end of a formula rate tariff as its own thing. We've said it implements 205.
right.
Feels like it's somewhere in the middle. I mean, you've heard the question.
Yes, so
help
yeah,
us out.
I was going to try and jump in and hopefully clear the waters. I think an initial question from you, Judge Pam, was sort of, are we talking about whether this provision is just and reasonable? And the answer is no, that's been decided. This is part of the, Section 5D is part of the filed rate. So cases like Seminole, the First Circuit Boston Edison case, and Oklahoma Gas say the question in this case is just whether it applies and should it be enforced, not whether as a policy matter it makes sense. If they wanted to change that, they would say the formula rate protocols are unjust and unreasonable. They would file a complaint under Section 206 and get the formula and the related protocols changed going forward. In this case,
And if they did that, they could get limited retrospective relief through the refund period, within the refund period?
also,
I mean, they couldn't go back as many years as they want.
well, to make things even more confusing. So just as to the protocol, that would be changed, and whatever they change it to, that would govern the next annual update, and whatever it says about going back under this tariff-based process, that would govern. In the cases where the commission is, where there is a Section 206 complaint and the party wants to get relief, putting aside, there's no similar protocol language at issue, but just in the abstract, if a party says, this is 2023, there's been I discovered an error, it's affected the rate since 2020, they bring a complaint under Section 206, what the commission has held there is that it can order retroactive relief. It's doing, and it's not bound by the time period in Section 206, the refund time periods, because, see your perplexity.
Oh, yeah, there's that other
It's using Section 309,
default.
and the
Yeah,
court
it's
has
coming
found
back to
that's,
me.
but again, that's not the case here, and the commission has made clear that this is if you want to go that route, you can. But we're talking here about the tariff-based challenge procedure, and that has to be governed by what the procedures say. We believe the commission's interpretation of 5D is consistent with the language. We talked a lot about the express language. I obviously think this falls right in. It's consistent with precedent and also policy. With respect to precedent, in the reply brief, the petitioners note that this is a copy of the protocols that were eventually developed in the commission's Midwest ISO proceeding, which sort of kicked off an industry-wide review of these formula rate protocols. And in the reply, they say, oh, we relied on that, we adopted that precedent. Well, if you look at final compliance order in that case, it expressly addressed this sentence that we're fighting about here today. And there's a lot of Midwest ISO cases, so it's 150 FERC 61025. And if you look at paragraph 35, some of the customers say, hey, we think we need to qualify this language more. It could be read as affecting our Section 206 rights. In paragraph 43, the transmission owners say, no, that language has nothing to do with Section 206. That's separate. All we're saying with this language is you can't use the challenge process to challenge prior rate years. Paragraph 50, the commission accepts the language. It says Section 206 is a separate thing. what this language is doing is saying that interested parties can only use this challenge process for the current rate year. So the Commission's interpretation of Section 5D is consistent with that. And it's also consistent with policy. You know, it put in place this robust protocol process to impose transparency obligations on the transmission owners, discovery obligations, there's a robust exchange of information, but it also wants the customers to be engaged, and the section limitation, Section 5D, encourages that and also furthers the goal of rate certainty, but it does so without affecting their ability, if they want, to pursue input errors going back in time.
Through 206.
Correct, correct. I'm happy to talk about any of the other issues if you have questions about the coal or the tax.
Let me ask you, I had thought on this first question, I had thought there were two parts to the question. One is, what does the tariff mean? And then the second is, did the agency adequately explain its decision to enforce the tariff limitation based on things it had said in other cases? And I'm just wondering, Judge Pan suggested, you know, maybe we don't even get to the second question if the tariff is unambiguous. If the tariff is unambiguous, it governs, unless it's inconsistent with the statute, and there's no statutory claim here.
Correct.
So that's the end of it.
Correct.
All we need to do is construe the tariff unambiguously in your favor, and then end of Q1.
I think that's correct. In paragraph 13 of the hearing order and elsewhere, the Commission has made clear that this isn't a statutory issue. It's just a tariff-based issue. We think the language compels the result here, but we also think if there is any ambiguity, the Commission's decision is certainly reasonable. Just if I can for a moment on the, there's been a lot of talk about what the Commission does in reviewing these formula rate filings and examining the inputs and what's permissible and what's not. Just to take a step back, the uniform system of accounts has 50, 100 something accounts. It tells the utility, this is where you put all your expenses, this is where you categorize your revenue. Those are the inputs. Formula rate takes those inputs and says, okay, we're going to put these accounts in this bucket. That's what the utility can charge its customers. We're going to take these accounts, put them in this bucket. That's what the utility has to cover itself. So in examining the formula rate updates each year, the Commission will make sure that the right costs are in the right account. It will also consider prudence challenges. Did you prudently incur those costs? But what it won't do is rearrange the buckets and say, oh, you don't think this account should be in the customer bucket. That has to be done. That's changing the formula rate, and that has to be done under Section 206. Unless there's any questions from the court, I'll stop there. Thank you, Your Honors.
We appreciate it. Guess we have an intervener. Yes. Mr. Kaiser, and you might want to lower the podium.
Hey, please the court, and yes, Your Honor, we have an intervener. I'm William Kaiser on behalf of the intervener, American Electric Power Service Corporation, supporting the Commission. So I want to take a minute because there was a lot of discussion about Section 205 and 206, and I'm happy to answer questions on that. But I do, and I think FERC counsel did a really good job of kind of explaining the nuances and how they work in the formula rate process. But I think it's important to recognize that when the protocols, both the protocols and the formula rate itself, which is the template as FERC counsel was explaining, are submitted by the utility. They're done so under Section 205 of the Federal Power Act. And FERC does review and approve both. Right? Once they're established, only then, and once FERC finds them just and reasonable or approves them, then you can challenge them under Section 206. But once they're established, the only way you can challenge that, including Section 5D, would be under a Section 206 complaint.
And during the establishment process, there's also an opportunity to, I guess, comment and
Absolutely.
oppose, for
Absolutely.
example, a section like 5D?
Absolutely. Yes, there's an opportunity for participants to intervene and raise challenges to it. And the commission will consider that and, will issue an order kind of ruling on those.
And that's what your friend was referring to in this MISO
Correct.
case, where there was a challenge that this was going to affect people's rights under 206, and there was a clarification that no, this is just a 205.
That is exactly right. And there's another case that we cite in our brief, which is one of our affiliates, American Electric Power East, where we had language in there limiting the ability to, not only similar language to here, where sort of limit the ability to go back after the annual update process is closed. We also had language in there limiting the ability to file a complaint under Section 206, trying to limit that, and the commission struck that and distinguished between the two. They said you could keep the language where you're limiting challenges, but you cannot limit rights under Section 206 because of statutory rights.
What's the site to that?
It's American Electric Power East. It's 124 for 61306.
Thank you.
And then how does the 5C tariff addendum, that catch-all provision, affect what you just mentioned with respect to going under 205 and then under 206?
So what 5C does, 5C limits the types of challenges that can be raised during the formal challenge process. Because what happens is FERC approves the formula or the template. And as we've talked about, inputs each year are updated based on costs of the utility. They're flowed through that formula rate template. And 5C limits the types of things that you can raise during the challenge process. One of the things you can't do, as Council for FERC explained, is you can't challenge the template itself. You can challenge the inputs, but not the template.
I was wondering whether this challenge falls under 205 and 206. I was thinking 206, and then I came across this opinion by Judge Williams, who was a great FERC expert. He said, seems more accurately akin to a continuance of the 205 proceeding because the annual update supplements the utility's initial 205 filing, which is simply a formula without the necessary inputs. You agree with that?
Yes. I think that's the Northern Virginia Electric Co-op.
So this proceeding before us is just the back end.
It is
finishing up the cleanup on the tariff.
I agree with, I don't know that I would characterize it as a cleanup. I think it's a supplement to.
Fair enough.
With respect, I believe it is a supplement to the 205 process, right? And that's what happens is
So you bear the burden of proof.
That is absolutely right.
This proceeding.
For the annual update process, when the inputs are provided, they're posted publicly. If a challenge is raised, the burden then falls on the utility to justify the costs that have been challenged by interested parties.
You bear the burden of justifying the formula on the front end, the inputs on the back end. That's all 205.
That's correct.
They can challenge under 206. They can make the fair and just argument for under 206 for going outside the refund period. So this is really all about who's going to bear the burden of proof.
In part, that's exactly right. It is about who's going to bear the burden of proof. And if you think about the challenge process, and I know I'm out of time, but if I could.
If we have questions, we'll let you go.
So what I just want to say to that, if you think about the way the challenge process works, it's the way the formula rate process works, the challenge process. Once the challenge process is complete, no different than a 205 case, right? Once the commission approves a rate filed under Section 205 of the Federal Power Act, it determines that rate is just and reasonable, and it stays in place, and the only way to challenge that is under Section 206. The same concept, logic would apply to the finality of Section 5.
And are these invariably separate proceedings under 205 versus 206? Like you can't argue 205, and in the alternative, I'm challenging under 206 in one case. Is that correct?
You could, I guess, you could try to raise a challenge under 206. You would bear the burden if you were going to raise 206 challenges. So if you filed one pleading raising a formal challenge and you filed a complaint on top of that, you would bear the burden. So it would be, it's a different type of pleading. You'd have to have more evidence, depending upon what the issues are.
So practically speaking, you wouldn't do it in one pleading because it's different. different standards, et cetera?
I would say maybe you could, it is possible.
Thank you.
Thank you very much.
Thank you.
Back up.
The podium is getting a workout this morning.
I'd like to address 2 points. First of all, the citation to the MISO cases. As we explained in fair amount of detail in our brief, the case that has been cited to you is the case on rehearing. What was the issue that was before FERC on rehearing? Customers did raise the backward error correction issue in the earlier case, but FERC didn't decide it. FERC instead decided to, quote, retain the requirement of the interested party submit an informal challenge. That would be a preliminary challenge to the beach protocol in order to raise any issue in a formal challenge. And then at paragraph 35 of the order of hearing, FERC summarized that argument and then agreed with it. So the claim that this has already been decided just isn't true. It's a new issue in this court in this particular case. Now, section 5C, which actually applies to the coal costs issue. Whatever the limitations there might be on customers as to what challenges they can bring, there's also a protocol, section 5F obligation, part of the utility, to justify its particular cost items. They can't do that. Those cost items are not used and useful. Also, an independent FERC obligation under section 205 to make sure the rates are just and reasonable. FERC can't do that if the costs are not used and useful.
Thank you, counsel. The case is submitted.